Hello, everyone, and welcome to Uncivil Law. For our first story today, we have the story of Rafif versus Oakland County. We are going to review the case from the Court of Appeals for the state of Michigan. This case is currently on appeal to the state Supreme Court. We do not have a decision yet, but we can read the decision below. In this case, a person's house was seized by the government because the person failed to pay $8.17 worth of taxes. The government sold the house out from under him, and then they kept all the money for the house. So he's not only out his $8.17 that he owed, but the tens or hundreds of thousands of dollars that his house cost. Rafif thinks that this is unfair. The court below did not think it was unfair. We're going to read the court decision below and try to understand the reasoning from the Court of Appeals, so let's get started with that. Each plaintiff owed property on which the defendants foreclosed because of tax delinquencies. The trial court found no such violations and ruled in connection with a motion for judgment that the plaintiff had forfeited their properties in the entirety. On appeal, the plaintiffs first argue that the statute is unconstitutional on its face because it violates the due process guarantees by prescribing insufficient steps for a government entity to take what it knows it has efforts to take. The Michigan Supreme Court ruled that where notices of tax delinquencies were returned to a county treasurer as undeliverable, the county was not entitled to proceed with foreclosure without taking reasonable follow-up methods. The court noted that reasonable follow-up measures directed at the possibility the addressee had moved would be to post notice on the front door or to send out notice to the address to the occupant. The court also pointed that although the government must take reasonable additional steps to notify the owner, it is not required to go so far as to search for the owner's new address in the phone book and other government records such as income tax rolls. Yes, heaven forbid that the government be forced to look at DMV records or other records that might give indication of where a person had moved to. Heaven forbid they do a basic records check of their own databases. Plaintiff argues that the statute falls short of the requirements of the prior law that foreclosing government units take additional steps when they know that they have attempts to serve notice have failed and therefore is unconstitutional on its face. However, the statutory provision is not unconstitutional on its face unless there are no set of circumstances under which it could be applied constitutionally. So here the court is alluding to the difference between a facial challenge and an as-applied challenge. When you're bringing up an objection to a statute facially, you're saying that on its face, it is illegal. When you're bringing it as an as-applied challenge, you're saying as it applies to you, it's illegal. So here the court is noting that a facial challenge does not succeed if there's any constitutional means of applying it. The statute does not authorize proceedings to foreclosure when notice consists of a single attempt at mailing that is known to be failed, but rather it specifies alternative means of identifying a valid address, mandates personal visits to the subject property, and sets forth requirements for notice by publication. We therefore reject the claim of facial unconstitutionality. So far, so good. The statute does appear to be facially valid. But what about as applied to this person? Let's read more. Plaintiffs next argue the statute as applies to each plaintiff resulted in a deprivation of constitutional due process. We do not agree. Well, so much for that as applies challenge. Oh well. We note that under the statute, the failure of the foreclosing governmental unit to comply with any provision of this section shall not invalidate any proceeding under the Act if the owner of the property interest or a person to whom a tax deed was issued is accorded the minimum due process required under the state constitution and the Constitution of the United States. The defendants did not simply rely on the mailing address they learned when it was ineffective. Rafaeli had paid taxes in 2012 and 2013 in response to notices of deficiencies sent to its address, as indicated on the subject property deed, but a third such notice prompted no such response. Apparently, defendants had no reason to doubt that the address ceased to be effective but for the lack of response. That literally makes no sense to me. Just because the address was valid in prior years does not follow it's valid this year. I don't know what the court is talking about. Additional steps then included a personal visit to the property where notice was left with a tenant, plus in identification of a residence agent and notice sent to Rafaeli's at an agent's address. Well, that does seem to be a little bit more promising. They gave notice to someone who was at the property and apparently sent it to some formalized agent as well. So that does seem to be enough process in terms of notice. Plaintiffs identify no major misstep on defendant's part when they complain that notice was sent to the corporation's identified resident agent's address was addressed to the corporation instead of the agent. Yes, if you're sending notice to the place where notice is supposed to be done, the fact that you put the corporate name instead of the agent name does seem to be like neither here nor there as far as notice goes. The efforts defendants undertook to serve notice on the Rafaeli satisfies the minimum requirement of due process insofar as the notice was intended to advise the corporation of tax liabilities and its property would be subject to foreclosure proceedings to satisfy the liabilities. The validity of the foreclosure depended not on perfect compliance with the statute, but on satisfying minimum constitutional due process requirements. By pointing out the defendant's agent failed to arrange for a return receipt in connection with the notice sent by certified mail, plaintiff essentially admits defendant had no reason, but for the lack of response, to doubt the attempted mail service was successful. Regardless, to the extent the United States Supreme Court admonishment that when mailed notice of a tax sale is returned unclaimed, the state must take additional steps to attempt to provide notice, so the qualification is that additional steps are required only if it's practical to do so. And as was the case with regard to this plaintiff, the plaintiff specifies no additional steps that might have been taken that would have better provided with notice. And that is a bit of a fatality to the argument. If you can't even provide hypothetical things that should have been done to provide you better notice, then you can't argue that enough wasn't done. So that does seem to follow. Plaintiffs next argue that defendants' administration of the statute's show cause hearing requirement allows them to play judge, jury, and executioner without any sort of procedural safeguards required by the due process claim. Plaintiffs contend the show cause hearings deprive the delinquent taxpayer of a meaningful opportunity to be heard, and we agree with the defendants that plaintiffs do not have standing to raise the issue. Why? Because plaintiffs did not participate in any show cause hearing below, and so suffered no injury from the manner in which such hearings are conducted. And that does seem to logically follow. Often in administrative processes, the processes that are given are much less formal than a court. But you can always appeal those decisions to a court, and you have to participate in those decisions, the same as they were anyway. So you would participate in the show cause hearing, and if you lost, you have the right to appeal that decision. But if you don't show up, then you basically forfeit your argument because you never gave the government a chance, you never gave the government fair notice that you had a problem with it. So you can't just say, well, this hearing doesn't give me notice or it doesn't give me due process. If you're unhappy with the results of the hearing, you appeal it through a court process. You can't just not show up. So that part does make sense. Usually you have to follow the administrative process and then go to the court if you're unhappy with the administrative result. Further, plaintiffs explain neither how they came to understand how defendants normally conduct such business, nor why they're so certain, had they appeared for their show cause hearing, defendants would have prevented them from exercising their statutory right to show cause in fact. Yeah, I kind of agree with the court analysis here. I don't know how you came upon this apparent knowledge, and you can't say they wouldn't have given me process if you don't give them a chance to give you process. You can only complain about actualities, and you didn't even give them a chance. So, that seems fair. In addition, plaintiffs have missed their opportunity to participate in a show cause hearing in connection with the respective parcels rendered moot any question concerning how well such a hearing would have comported. A case is moot when it presents only abstract questions. Yeah, same analysis. Again, we don't have to analyze whether or not it would have been sufficient. You didn't even participate at all. So the whole thing was rendered moot by your own lack of participation. So that was a major oopsie on your part. Yeah, I know, Lint, right? Yeah, all you heard from the headlines is how they were cheated out of $8.17. But you go read the case, and a lot of this is like, oh, no, it's not that way at all. Now, we'll get to the fine issue, because I still think that's valid, but the due process issues, I don't have any sympathy with them on the due process issues. It looks like they actually did have notice in fact. So it's not even like we didn't have notice in fact, because they were aware of the hearing to not participate. So it's like, yeah, you didn't give us notice the right way, but you actually had notice. In fact. So, okay, yeah. Because plaintiffs suffered no injury relating to how the defendant's conduct showed cause hearing, and one can only speculate concerning what might have transpired had they appeared for one and demanded their rights, the issue is moot. Plaintiffs next argue that the statute is unconstitutional because it mandates that government entities retain proceeds beyond those required to satisfy the delinquent tax bills. They argue that therefore allows unconstitutional takings. We disagree. This line of argument is significantly more promising. The United States Supreme Court has recently held that the excess fines clause does apply to the states, and so one could view this as an excess fine. He owed $8.17 on property. It's reasonable for the government to seize the property to pay that tax bill, even though it's $8.17. If it were 1 cent, they could do it. Whether or not they get to keep the excess is a whole nother set of problems, and one could view it as an excess fine in light of recent Supreme Court precedent. So I think this is a more promising line of argument. Let's see what the court says. This issue is easily resolved by reference to a case called Bennis. In Bennis, the court set forth the following summary. The petitioner was a joint owner with her husband of an automobile in which the husband engaged in sexual activity with a prostitute. A Michigan court ordered the automobile forfeited as a public nuisance with no offset, notwithstanding the lack of knowledge for the activity. We hold the Michigan court order did not offend due process clause of the 14th Amendment or taking clause of the 5th Amendment. While this is very relevant U.S. Supreme Court precedent and is directly on point with the example, I would take note that it is questionable whether or not it is still valid in light of the Supreme Court's recent guidelines and recent decisions when it comes to the excess fine clause as it relates to the states. The recent decisions from the U.S. Supreme Court, in fact, from this term and last term, somewhat undermine the United States Supreme Court's decision from 1996. So if I were looking at this case, I would say that this holding is questionable as to whether or not it still has legal validity in light of later cases that follow. So while on the surface it appears to be on point, at least in my opinion, later cases hold it as questionable whether or not it is still good law. Defendants obtained the property by way of a statutory scheme that did not violate due process. The Constitution does not require them to compensate plaintiff for lawfully obtained property. And this probably will seem very familiar to the case where we discussed the police people who basically put so many holes in a home during trying to get a burglar out that they, caused so much harm to the home had to be destroyed. It's not eminent domain taking. It's taking for police action. And so there's typically no compensation that is required for that under the current case law. But because the amount here was so minimal in value of the property and the excess fine clause, I think that the upper court may re-examine this. So that is the end of the case of Rafaeli versus Oakland County. In this case, we learned that a property owner had a delinquent tax bill of $8.17. In order to recover for this tax bill, the government seized the property, foreclosed on it, sold it, and then kept all the money from the house. We learned that he complained that there was lack of due process. We learned that this argument did not hold water. It looks like he had notice in fact and decided not to participate because he thought it was a sham. But he has to give the government an opportunity, and he has to find out for a fact it's a sham. If it was a sham, he would have had all the standing in the world to appeal that to a court because it was a sham process. But he didn't even participate. And so the whole issue is rendered moot by his own actions. So that was a bad move on his part. As to the excess fine issue, I think in light of current Supreme Court precedent, the 1996 case from the U.S. Supreme Court is questionable as to whether or not it is still good law. So I think that the upper court, when looking at this and looking at the excess fine clause, may take cause to re-examine this. And we will see what happens because I think it's a very interesting interaction on trying to form new law. So we will see what happens next.